Izham to now join the rest of the speakers, Datuk, Sundra and Benoit, to sit on the couches on the front of the stage, as I'd like to now invite our moderator of the session, Mr. Farez, Jinnah, to moderate this session. And where for this panel discussion, I'll let the moderator kickstart the discussion, but inevitably, I'm sure we'll be expecting some very interesting questions from the floor, arising from the lively presentations from all of the three speakers. Farez, yes, go ahead.
Yes, thank you, Lishi. Datuk Sundra, Benoit, Izham, thank you for joining us. I would actually like to start off with the flavor of the day, which would be the Pechstein case. Now, as you have gone in quite detail, in quite a lot of depth, Benoit, can I just swing it first to Datuk Sundra? How do you feel? What are your thoughts of that decision? Are there any issues that we have to look to or be aware of in Malaysia?
I think it shows the role of the courts vis-a-vis, because it's very interesting that the lex arbitri of that arbitration is in Switzerland, and the injunction almost was sought in Germany. It's a very interesting situation where, in actual fact, the Swiss court has upheld the arbitral award, in actual fact, and then the German court has come out because a concurrent action was actually filed in the German courts. And I took the point of what res judicata. I think that was very, very clear to me. This is actually a perennial problem that we face when we have people filing multiple suits, and it is something that is expected. Is expected, but I think it resolves itself eventually when there is. It is not actually the norm. I suspect the case is actually a one-off case, and it will not affect other than the fact that that she was able to get some remedies, and that remedy is only to her. Eventually, I think we cannot take it as the ruling theory of arbitration in the world. So I think it is of limited. I mean, people are quite pessimistic. I suppose we are shocked by what the German court did, and we do not expect that. So I suppose the German court would have been criticized, especially in arbitral circles, if it happened to them. They are lex arbitri. That means they had an arbitration decision which they had upheld, and then it is actually acted similarly by a Swiss court. So I think it is limited. I do not think that it is going to have any effect in the overall picture of promoting arbitration, as the method of resolving disputes in sports. I really don't think it's going to be. But I think it's a shock. I was listening to the case and I said, hey, this is the German court. How come they're doing this?
But it does bring up a very interesting perspective on the players' ability to choose their forums. And you also pointed out that only 1/5 of the arbitrators on the ICAS panel, am I right? What do you call that? Player appointed. I'm sorry?
On the ICAS.
Yes, on the ICAS panel, 1/5 of them are appointed appointed by the players or athletes themselves. This is a problem. How do you see that? Are there any movements in that direction to solve that problem?
I think the first step would be for the athletes to create unions, to give more power to their voice, and before entering into any arbitration agreement, to raise the legal issue, saying, no, I don't agree with the arbitration agreement. I would like to have my case heard in front of a state court. But then the sporting organization would say, okay, fine for you, but you don't participate in our championship then. So if you want to participate in that championship, you have to sign. So it's a monopolist position from the organization, sporting organization. But in my point of view, it had worked until now very well. The independence of CAS has been challenged several times in front of the Swiss Federal Tribunal. Never it had been accepted by or confirmed by the Swiss Federal Tribunal that CAS is not independent. So I think if the outcome of the Pechstein case is in favor of the athlete, then it will open the door for every single athlete to go first through CAS, Swiss Federal Tribunal, and then claim for damages in front of his or her state court in her country.
So this would also involve Izham. What are your thoughts on unionizing? And the second question I have for you is this: how is it that, say, local player contracts do not meet the minimum FIFA requirements? And are there any sanctions, or is it something that perhaps FAM in Malaysia are allowed to opt out from?
To answer your first question, it's very important for the players to unionize themselves, and the players have to understand their rights and responsibility, and their voice are being heard more if they come in groups. So I think being in a union, we have more power for the players, and also being in a union like PFAM, which is also an affiliate member of FIFPro, which is a bigger union representing players around the world. We have a much more complex issues that we can deal with, and it's very important for the players to be in a union. And to answer your second question is there is something that this is a debate whether a circular of FIFA can be adopted or not, or is it binding for the National Association or Members Association to adopt. And there is a debate whether regulations such as status and transfer players regulation is adopted well in Malaysia. Regulation of status and transfer of players is a FIFA regulation which is adopted all over the world. But in Malaysia, it is adopted by FAM but not in entirety. There are certain provisions that has been amended and also modified with the understanding that it should suit the local situation in Malaysia. But in the case of standard contract requirement, it is not adopted at all in Malaysia. It seems that the Football Association of Malaysia pick and choose the regulation that they want. There are so many other regulations that has not been adopted in Malaysian football, one of it being the FIFA NDRC, with the need for every members association to establish a national dispute resolution chamber of FIFA, and that is also not being adopted in Malaysia. So it seems that the members association can adopt or not, but there has to be a moral obligation for the football authorities to ensure that professional careers through a more established or more efficient contract mechanism is being implemented.
Datuk Sundra, how would MSAT cover situations that PFAM are now facing?
By way of a written arbitration clause, I suppose, which we hope that written arbitration clause to be statutorily implied into the articles of association of each organization. So it will be actually quite a unique setup that what we are proposing, the amendment to the Sports Development Act, that it will be deemed that every association has this arbitration clause, and if there's any dispute arising thereof, it will be referred to the MSAC for, in accordance to the rules, to come up with a resolution based on the constitution or the contract that the parties have entered. So,
I'm sorry, Luke.
No, it's all right.
Yeah. So you would foresee that a lot of the issues that PFAM has raised would also more or less sort itself out?
I don't know. to be truthful, it is something that we actually want to create as an avenue. It is actually based on CAS. CAS actually gets the institutions itself, the organizations, to have this arrangement in their constitution, I suppose. And then when the players, they also, when they will sign some document that they say they are going to be bound by what this the provision of the various organizations have. So I think by that, then they actually, when there is a dispute, then it goes to CAS. So I think we will have to do something like that. But only thing is that because it's very difficult to get everybody to amend, to put it in, we want to do it by law. We have seen that through statutory adjudication, so we know it can be done, but only thing is that we have to provide a mechanism that really works. There's no turning back, so we cannot set up an inefficient mechanism. That's why we are a bit concerned, and we are going to do it well. I think where the KLRCA is concerned, we have some experience in doing this. We are very confident that we can set up the system at the beginning by subsidizing it. But eventually, I think somebody has to pay for it, just like in CAS. But it will not be as expensive. Again, I think one of the issues that's always been is whether if you allow lawyers into the system, whether the cost will go up. I don't know. I think it may be by other ways. You can allow lawyers in, but you can limit the cost of what can be recovered. So you spend so much money, but you will never recover it. Then I think people may think twice in doing it. But of course, I think that we are still not sure how. But the structure is there. But I think the best example is how CAS has come out originally, and then we will work along that way. But what we are planning to do is to kickstart by a statutory provision.
Thank you. Benoit, any thoughts on this?
Just one remark on the legal representative of the parties. CAS has implemented legal aid for parties, meaning that they will provide, I think, a list of lawyers who will work pro bono for parties who don't have the financial capabilities to lodge a claim in front of CAS. So CAS has implemented that system recently.
Can I leave it to the floor? Any questions from the floor?
Izham, this is basically Chris, and we talked about English football. And basically somebody else came said, well, we don't follow Malaysian football because we are ranking somewhere, what, now 130th in the world? Or FIFA
466.
466. 166, sorry, sir. All right. So now, Izham, all I can tell you is this. I'm very proud of what you are doing, because it is not good enough to blame our players for not reaching the ranks. And you have started on the right path, and hopefully in another 10 years or so, we may improve in our ranking. I think, it's difficult to play football if you don't get paid, right? You got to eat, and you got to eat good food as well. So my hope is that you carry on the good work and get as much support as you can, and the KLRCA will be here to work on the rules, on arbitration, and so on. And I definitely wish you all the best. Thank you.
Question.
Thank you. Firstly, excellent presentations from all three presenters. I thought they were fantastic. But particularly my question, firstly, is directed to Benoit. In the Pechstein case, firstly, are you able to say when it's likely, or do you know when the German Supreme Court decision is likely to be handed down? And then secondly, in terms of the future of CAS, do you have any comment to make about this problematic juridical basis in a general sense as to how it is that there's no bargaining power between the participant and the sports organisation, not just to the arbitration clause, but to a lot of other clauses and policies in sports arbitration agreements. So whether or not, as the German higher regional court found on monopolies grounds in Pechstein, and expressed concerns about the clause, or in the common law world on unconscionability and inequality of bargaining power, or indeed, as Clyde Croft has recently remarked in Sauber, query whether or not CAS awards are really commercial arbitration awards. All of these things have happened, all of these concerns have come to light really in the last 12 months. Do you have any comment or any view on how that might affect the future of CAS? And Datuk, I'd be interested in your views on this as well, if like you had views on the future of CAS based upon these new attacks to the basis of the CAS jurisdiction.
Thank you, Paul. I will give meaningful. As you know, FIFA recognized CAS as the arbitral tribunal, and even though the confederation like the AFC or UEFA are not part of FIFA but only recognized, we have to abide to their statutes, to the FIFA statutes. So at our level, for the moment, we are not able to amend those clauses, meaning that FIFA is the one having the power to tell CAS and say, look, your arbitration clause, now you have to give more power to the players, to the clubs, or maybe some referees, because a lot of appeals are against referees' decisions and so on. So it's in the hand of FIFA. Of course, the member association, the 209 member association of FIFA would have a lot of power to go against FIFA and say, look, we have our clubs, we have our players, referees unions who are unhappy. So please refer it to ICAS and ask them, for instance, for the ICAS composition. Give more power to the stakeholders. Give less power to the international federations. Have a balance. So, but it will take time. So, what I suggest is let's wait and see the decision of the German court. And I know that CAS, following the German court on the second instance decision, decided to publish a media release because they thought, okay, we are in danger, so we need to be proactive and publish a media release stating all the good things they have done until now and all the reforms they have implemented. And they even went to Germany to meet the Sport Commission in the Parliament to explain the work of the CAS, the functioning of the ICAS. So maybe it's good that that case comes up and will shake a little bit CAS and ICAS, and they will reform some part of the area like the composition of ICAS.
Can I say something? It's quite interesting, you know. I was trying to understand. I suspect that it was resisting an enforcement of the act, isn't it? Enforcement of the award in Germany. Basically registration and enforcement. So it would be under the New York Convention. And I suppose what was used was a public policy provision. And the public policy provision is the anti-competition arrangement. That means, and this is actually a European regulation. Correct? Right? I'm so, I think it's going to have limited place. It will only happen in Europe. So I think in fact, if UK leaves Europe after the present election, then perhaps it won't apply anymore. So I think so we have to be very, very conscious on what it's very interesting that ICAS quickly reformed its structure and tried to respond, because I think Europe must be a very big market for ICAS in terms of number of cases coming through. So in Asia, I don't know whether there will be a public policy thing. Let's say, for example, we have the Competitions Commission. Whether a Competitions Commission in Malaysia can actually put the same kind of rules to a institution that is set up in Switzerland. This is about public international law, you know. So it's quite interesting. That's why I personally feel it's going to be very limited application, simply because the New York Convention provisions and the rectification in various countries are slightly different and may not encompass the European regulation as regards to anti-competition.
Thank you. Do we have any more questions from the floor? All right. I suppose we will call it a day. Yes. Thank you, Datuk. Thank you, Benoit. Izham.
Thank you to the Mr. Moderator as well as to the speakers for the very engaging session.